Okay, we're ready to go.
Great. Thank you all for attending. This is the March 16th meeting of the Milford Planning and Zoning Board. If we could have the Pledge of Allegiance and a moment of silence, please. I pledge allegiance.
Pledge allegiance to the flag of the United States of America
and
to the republic for which it stands,
one nation, under God,
indivisible, liberty and justice.
justice for all.
Okay, thank you. Meg, if you would call the roll.
Sure. Ms. Austin,
Present.
Mr. Castagnoli,
here,
Mr. Cater,
Present.
Mr. Collegian,
Present.
Ms. Kearney,
Present.
Mr. Mortimer,
Present.
Mr. Moore,
Present.
Mr. Sadi.
He's there. He's setting up.
Okay, great. Mr. Zaharidis.
No, I don't see Mark.
Okay, thank you.
Okay, and I'm here.
Oh, sorry, Jim. Mr. Chair.
Okay. First order of business is a public hearing closed by April 20th, 2021. Vote by June 24th, 2021. This is a public hearing that has remained open. And it is 67 Prospect Street, Zone MCDD, petition of Patrick Rose of Rose, Tissot and Company for a site plan review with the coastal area site plan review for a proposed mixed-use commercial building on map 54, block 817, parcel 6, of which 67 Prospect Street LLC is the owner. The applicant has the floor.
Thank you, Mr. Chairman. And once again, good evening, members of the board. For the record, Thomas Lynch with the law firm of Lynch, Trimbicki and Boynton. My office is located here in Milford at 63 Cherry Street. And I'm representing the applicant on this matter and the owner of the property, 67 Prospect Street LLC. So we left off at the last public hearing with, I believe, 3 open items that needed to be addressed. And I'm happy to say that we've spent a lot of time over the last 3 weeks addressing concerns that the neighbors had raised, as well as making some amendments to our site plan. And also one issue was basically a legal opinion or some input from the city attorney's office as to the board's discretion or the level of discretion that they have in terms of entertaining a site plan application such as this. So I'm going to reiterate some of the comments that I made at the other public hearing, and I believe David can supplement those with some input from the city attorney's office. But we left off at the last meeting going back to the drawing board, and with me tonight is both Manny Silva and Pat Rose of Rose Tissot, who've spent a lot of time working on this. Manny's going to go into a little more detail than I will in my overbrush in terms of discussing some of the changes and revisions that we made to the site plan. But the first matter was to address some of the concerns of the neighbors on Prospect Street relative to traffic or issues resulting from delivery trucks coming onto the property. And Manny is going to go through a revision that he made to the site plan that will show that there's now a truck turnaround that's been installed on the property to allow trucks to come onto the property. Amazon or UPS or FedEx delivery trucks come onto the property, make deliveries, and then turn around without having to back out into Prospect Street. So we think that that's a very good remedy to the concerns that were raised by some of the neighbors, rightfully so. And that's why the time since the last public hearing to tonight enabled us to, like I said, address those. Also, there was some discussion, I believe, mostly comments that Ray Oliver had made during the last public hearing relative to shrubbery and tree buffer along the rear of the property line. That's also been addressed with a revision to the site plan. So Manny is going to discuss that after I'm done with my comments. There was discussion about the drainage that was provided. And again, I reiterate to you that we came to you at the initial public hearing with a drainage plan that would accommodate retention onto the property and the management of stormwater runoff onto the property up to the level of a 100-year storm. And those plans were reviewed by Greg Podleski, our city engineer. That's why you have a city engineer to review the plans. That's his job to see that the needs of the city of Milford are met and that any plan that comes before you, addresses in a professional manner concerns that neighbors may have of water runoff or other drainage concerns. So our initial plan was reviewed by Greg. You have a memo from the city engineer that says that the drainage plan that we've proposed is adequate and services the property and will service the needs of neighbors to ensure that there isn't water runoff. At the last public hearing, it was suggested that a meeting be held between Manny, our engineer, Greg, the city engineer, and Bob Heiza, who had been hired by the Milford Cemetery Association to review the drainage plans. There was a memo that Mr. Heiza had submitted to the board prior to the first public hearing that seemed to be, for lack of a better terminology, seemed to be somewhat inconsistent with understanding the nature of the original plan that was proposed. I believe that Mr. Heiza's original memo to you talked about the drainage plan accommodating a 25-year storm, where in fact, the plans that we submitted to you would accommodate runoff from a 100-year storm. So on March 4th, a meeting was held in Ray Oliver's office between the three engineers. I'll let Manny go into further detail as to the result of that. But in your documents, I believe it was uploaded into the website, appearing in the documents at page 35, is a report that was issued after that meeting from Mr. Heiza, basically saying that he has reviewed the drainage plan, and although reluctantly, he says that the plan is adequate to service the water runoff, to have it retained on the property. He had originally proposed a different type of method of dealing with the drainage, but his conclusion in his report was that the proposal as submitted to you is adequate. It does also provide for the fact that during the construction of the drainage, Mr. Heiza and the city engineer will meet with Manny on site to do additional test holes to make sure that Manny's calculations were based upon water levels existing on the site from the test holes that he had originally done. And if there's any alterations to the drainage plan that may be required at that time, that'll be reviewed by the city engineer, and any recommendations that he makes, then my clients would be willing to accommodate, and certainly that can be made part of any approval that the board makes tonight, if in fact there's a vote taken to approve this application. So that leaves the last item that was left as open. I know that there was some discussion to get an opinion from the city attorney. I'm just going to, reiterate the comments that I made at the prior public hearing, again, to the fact that this is a site plan application that's being presented to you. This is a conforming permitted use under the zoning regulations, and particularly as they pertain to the Milford Center Design District. The building is a permitted building, subject to a site plan that conforms with the zoning regulations. And I know that there was discussion at the last hearing as to what is the board's discretion under section 7.1 of our zoning regulations in terms of reviewing a site plan. And I submit to you that there is none. Case law in Connecticut is clear. These regulations contain general language as to the elements of a site plan and that a proposed use being of character to an area. But I submit to you that a permitted use by definition is a use that is of character to an area. And there is in fact, a case that I was involved in 1998. The name of the case is Smith versus the Milford Planning and Zoning Board. For those who want to write down a citation, it's cited at 198 Westlaw 881846. And you can't find a case that's more on point with the issue that's raised here tonight than this case. In 1998, I represented Bob Smith and Phil Kraft when they were purchasing the old Captain's Galley restaurant building on the corner of Noble Avenue and Broad Street. Frosty Smith and Dan Smith owned the property across the street at the end of the Milford Green. And we appeared before the Milford Planning and Zoning Board with a site plan application to convert the restaurant building into a medical office building. And for whatever reasons they saw fit at that time, the Smith brothers brought an appeal of the decision of this board to approve the site plan. And the court in that case upheld the board's approval, specifically addressing the language in section 713 of the Milford zoning regulations. And I know that we concluded the last public hearing with board members looking at the language in section 713 of the zoning regulations and saying, what does this allow us to do? What discretion does this allow in our review of a site plan? And the court went into great detail to talk about that. And I normally don't like to do this in my presentations to you, but I'm doing it tonight because it's so germane that it's very, very important to make part of the record. And the court said in that decision, page 3 of the decision, the court said, quote, "A site plan may be modified or denied only if it fails to comply with the requirements already set forth in the zoning regulations. The standards and requirements in Milford for site plans and approval by the board are established in Article 7 of the Milford zoning regulations. Section 7.1 of the regulations provides general language as to what the board has to look at when someone comes in with a site plan application. In this case, the plaintiffs, meaning the Smith brothers, argued that Smith and Kraft's site plan failed to comply with several subsections of section 713 and therefore could not be approved. Those general discussions, general considerations, general objectives, and these are all quote from the court case, found in 713 of the regulations cannot serve as the basis for denying this application. And the court cited a case called TLC Development Inc. versus the Planning and Zoning Commission, cited at 215, page 533 of the Connecticut reports. The court further quoted, "The provisions under section 713 cited by the plaintiffs are not requirements already set forth in the zoning regulations. Rather, they merely establish general guidelines for the board to follow and lack any definitive standards. Thus, section 713 and following could not be the basis for denying the application for approval of a site plan." Now, this is a 1998 case where the court specifically analyzes section 713 of our zoning regulations and makes it clear that the board, acting in this capacity, in reviewing a site plan, the board has no discretion in approving or in terms of denying an application that meets all of the zoning regulations. And that's what this site plan does. The building is proposed, the setbacks is proposed, the lot coverage, the drainage, all of the other elements that are set forth in section 7 of our regulations, requirements of a site plan have been met. They've been reviewed by David. He has issued a memo to you that the project is zoning compliant. So, you know I've been repeating myself the other night and I'm doing it again tonight, but it's a legal maxim that this is a permitted use in the zone. The site plan conforms with the zoning regulations. The board does not have the discretion to deny such an application as this. If I was coming before you with a client that was seeking approval of a special use in this zone, such as a health club or a church or a theater, those are special uses where the board does have discretion to look at it and say, all right, is this location on Prospect Street appropriate for a church? Is it appropriate for an amusement center? Is it appropriate for a fraternal organization? You have the discretion in that case to deny. But when someone comes in with an application that has a permitted use in a mixed use building with an office and residential component, is a permitted use. By definition, it meets the standards under section 713 for uses that are compatible to the area. So that's my speech to you. And I'm going to turn things over to Manny, and he's going to talk in more detail the revisions that he made to the site plan.
Okay, yeah, thank you, Tom. Manny, you have the floor.
Good evening. I just need to screen share if I can.
Sure.
Okay. Manny Silva from Rose T-Zone Company, 35 Brentwood Avenue, Fairfield, Connecticut. The project engineer for the project. Again, Mr. Lynch detailed what I'm basically going to go over. And one of the comments from the neighborhood was a concern about vehicles having to back out and not being able to turn around on site. So what we did is we applied a turning template for delivery vehicles to the site, and we adjusted the parking here to then allow a loading space here where Amazon and UPS and FedEx can come in, back straight out, and then come out of the site. Again, we applied the turning template to the actual dumpster enclosure too, so that you can see that dumpster truck comes, picks it up, backs out, and then is able to leave. The next thing we have is the landscaping plan, where the cemetery asked us to have the same screening. So basically, we had an evergreen screening around the north and south of the property, and now we've added an evergreen screen along the east side of the property, which neighbors the cemetery. And the last thing is the meeting that we had with the 3 engineers, myself, Craig from the city of Milford, and Mr. Haza. And he here pretty much outlines, due to the concerns regarding the parameters, Mr. Silva agreed to do additional field testing to determine the max groundwater level, because we did 2 test holes on site prior back in 2017, found that the groundwater level was acceptable for the 4x4 galleries, and Mr. Haza asked us to confirm that prior to building the gallery system, and then we'll confirm that. Again, I expect to find the same results, but if not, we can adjust the design to do 2-foot galleries, as he's saying here, which makes it more shallow. But I don't anticipate that at this time. And again, in his conclusion, he approves the proposed drainage retention system to manage the 100-year storm in event with 0 runoff. And again, so now you have basically 3 engineers saying that the system will perform up to the 100-year storm with a zero runoff to any neighboring properties. And I think those are the three things that I was here to cover. And if there's any questions, I'm here to answer them.
Thank you. I have a question. When you looked at the turning radius that you provided, are you looking at what is the criteria that you use to determine that that's sufficient?
So we use the DOT's standard for delivery vehicles and basically garbage trucks, which is, we have it right on here. It's the DL23 standard. So basically we use the DOT standard for delivery vehicles.
Okay, could you describe that process to me? Do they come in? Do they back into the parking lot? Do they back out of the parking lot? How does it work?
So they pull in, straight in, just like anyone else. And then delivery vehicles will be parking right here in this striped space. And they'll back straight towards this garage exit or garage door here. And then they'll just turn around and go straight forward right up the property. Same thing with the garbage pickup. Garbage pickup pulls straight in, comes straight in, picks up the garbage container, backs up here, and then comes straight out forward out into Prospect Street. So there's no.
What did you use for a vehicle length?
It's 30 feet. It's a 30-foot length. So that's the DL20. The DL23 is really the 23 from axle to axle, but the overall length is about approximately 30 feet.
And what is the standard for a? Now that's a 2-yard box for the trash.
Yeah, it's about a 2-yard. Yep.
What is the size of the vehicle that picks that up?
That is essentially a 30-foot vehicle. You know, the kind with the fork in the front, or really it depends on the trash hauler. Some of them have the ones with the forks in the front. Some of them use the hook truck in the back. Either way, they'll be able to navigate this 3-point turn here.
So you're saying that the vehicle would have a 3-point turn?
Yeah, they have 1, 2, 3. Actually, it's technically 2 turns, but that's considered a 3-point turn. It's like any kind of hammerhead turnaround.
Okay, thank you.
You're welcome.
David, is there anything you can do? I'm getting a text message from Mr. Sadie. He's having difficulty getting in. Is there anything you can do to assist that?
No, I've been monitoring his comings and goings, but it's not on our end.
What about a phone participation? Do you have a phone number up on the?
Yeah, that's in the emails that were sent to him. There's always the phone connection there.
Okay, let me. Sorry about this. Just give me 1 second here.
Let me see here.
We've actually been pretty lucky for the last few months. We had serious issues the first couple of months, but we've been fairly smooth since then.
Yeah, let me take a picture of this and I'll send it to him. Hold on.
So, Manny, is there anything else you want to say before we give it back to Attorney Lynch?
No, I think we had the 3 that I had, basically as concerns to answer. I think we've addressed, and I appreciate you hearing us and allowing us to revise the drawings and deal with the concerns.
Can you speak to the landscape plan?
Sure. Sure.
So what we have, if we're looking at the front of the old structure from Prospect Street, to the left of that, I see it looks like 3 small hedges and 4 trees, and then 8 small hedges. Could you describe what those are, what their heights are? My basic interest in that is visual scale, right? So if we have a 35 or 38 foot building and we have a 2-foot hedge in front of it, it's not really mitigating a feeling from the street that it's out of scale and that the building is out of scale. So if you could describe what's there proposed, what's the planting height, and what's the growth height?
Okay, so basically from the street, you have the existing building, which is a 2.5 story building. I think it's 2 to 2.5 stories. And then in the front, these hedges are spreading yews, so that's basically a ground cover. And then what we have here is a red oak tree. And as you know, we'll plant those red oak trees at around 3-inch caliper, 3.5. So that will make
Which
the tree.
one? I'm sorry, I was distracted. Which one are you pointing at? Okay, the front one.
Yeah, that's
Okay.
a red. So that'll grow, as you know, over time, can grow quite substantial in height. And then we have these 2 Atlantic cedars kind of as to basically to act as a visual barrier of this area in here on the side of the existing house that's to remain. And those will be planted at 6 feet, but those will grow, pretty quickly. White Atlantic cedar can grow, 30 feet high. And then we also have another deciduous red oak here in the courtyard here in the back, kind of as a shade tree. But again, I think that with a combination of the existing building in the front, along with some evergreen trees here in the middle, the yews in the front are just for ground cover basically. And then we have our screening on the side, which is a combination of white cedar and then these 3 blue Wichita blue. They're kind of acting like arborvitaes, but we use the junipers instead of the arborvitaes because their deer don't seem to deer like arborvitaes. They seem to eat them. And the junipers are more resistant to the deer, and they maintain a visual screening just like the arborvitaes would. So I think that's.
And could you tell us what is the planting height and say what's the 5-year height?
So for the red oak, I would say it would be around 15 feet high in the 5-year, and then the as it goes in, it'd probably be around 3-inch caliper. It's like an 8-foot tree, 8 to 10 foot tree.
Which one's the 8 to 10 foot tree after 5 years?
That's
the front?
No, that's as it installed, it'll be about 10 foot, 8 to 10 foot tree.
Okay, got you. Okay, sorry.
And that's the red oaks. And then about at 5 years, they should be around 15 feet, I would say. And then the Atlantic cedars will go in at 8 feet and they'll grow a little slower, but we should be around, but again, we're putting them in a little taller. So they should be around, somewhere around 15 feet also.
So, I really don't know much about this horticulture, but is it possible to get more mature trees from the get-go and plant maybe, 15 or 20 foot trees in construction process, and then they grow, higher in the 5-year horizon from there? Is that even legitimately possible?
I mean, nothing's impossible, right? So you could get some mature trees. They are harder to come by, and they are a lot harder to get here without damaging them. So we're using it we are using what is on the bigger side of what you would normally put in for a tree new. So a 3-inch caliper is a pretty thick tree. And then 8-foot high cedar right off the pallet is a pretty big tree. But I mean, you could get a 15-foot tree. These two, I guess we could get these two cedars as 15 feet. I mean, it's going to cost a little bit to get here and transport it here. And we'd have to find it. But definitely.
No, thank you. Yeah, I was just curious. Thank you.
No problem.
Attorney Lynch, would
Yes.
you like to continue?
I think that's the extent of our presentation to you, Mr. Chairman.
Okay.
With the revisions that we came in with tonight, and again, I leave it to David to report from his discussion with the city attorney, but I just want to ask the board to just consider the fact that this has really been a 3-year process. This started before the Milford Preservation Commission. And what we're bringing to you tonight, and Mr. Chairman, you even concluded your comments at the end of the last meeting, the fact that this is a project that was reached in a settlement with the city of Milford in court as a result of the action taken by the Milford Historic Preservation Commission. This project involves the saving of the Baldwin House. It involves the restoration of the Baldwin House, which is a historic home that is in much needed condition of renovation, and it will be renovated as part of this project. So I think that our comments speak for themselves, and I trust that the board will do the right thing and apply the zoning regulations and the law in their consideration of this application. Thanks.
Thank you. Any questions or comments from the board? At this point, then, I would open up to the public. Anyone that would like to speak, please either come on electronically through the Zoom platform or raise your hand. David will be the gatekeeper. Please keep your comments to about 3 minutes. If you say the same thing someone else did, maybe just concur with them rather than reiterate everything. But feel free to say your piece as well. If you would state your name and address for the board. So David, I would hand over the gate to you.
Okay, I am searching our screens for a waved hand. Once again, I see Alice Oliver would like to speak. Otherwise known as Ray, but he has to unmute. Unmute.
Okay, is that all right?
Yep.
Thank you. My name is Ray Oliver. My address is 404 Gold Street. I'm here representing the Milford Cemetery as Vice President of the Cemetery Association. And I'd like to review some of the comments that were made about the site drainage and the meetings that were held between the engineers. I'm sorry that Bob Heiza can't be here personally to go over this, but I told him that I would do my best to try to interpret what he got from the meetings and what his assessment is. So there was a meeting with Manny Silva, the project's engineer, and the city engineer, Greg Wilski, and Bob Heiza, the engineer the civil engineer that the cemetery hired for analysis. Manny reviewed his present design, which is a retention system for a 100-year storm. And what that means is that half of the gallonage that comes to the site will be stored in the galleries, and half will be assumed to be percolating through the ground as it falls. So there are two sort of unknowns about that at this point. One is that we don't know what the ground water, what the table is, what the water table is in the ground. The cemetery superintendent says that it's less than 4 feet. The engineers' reports say that they didn't discover it. So that's quite an unknown at this point. The other part of it is that it's unknown what the exact percolation rate is. So when they assume that half of this flow is going to go into the ground immediately, that's an unknown. Greg Pogowski and Bob Heise said that they're willing to assess and view deep pit tests and more percolation tests when the project is underway. The problem with that is, what if it isn't? Now, the groundwater situation may be able to be handled by the what Manny Silva says is to spread more of the galleries out over a bigger area and a more shallow system of 2 feet rather than 4 feet. But as Bob says, the retention system doesn't replicate conditions that are artificially can raise the groundwater. So even though the sort of overall idea that you can retain a 100-year storm, that doesn't mean that at this point we know that that's going to work. And Bob Heise's assessment is that there still should have been a high and low water outflow from this system to ensure that the groundwater within that area where the water table is not raised. Now, Manny Silva said, well, there's no way that we could have gotten an approval for a system that piped the water either down to the catch basin by the railroad track or across the street past John Wicko's property directly into the Weepawaug River, which would have allowed that water to dissipate in a functional way, in a normal way. He said that there would be many hours and possibly years of approvals that would be needed to do that. In the meantime, this project has been submitted since 2017, and that's 4 years where they would have had time to really develop a system that positively works and is not going to affect the cemetery or the DAR property. So I don't really see that your approval, your conditional approval of this project is necessary, given that the time to allow for an actual system that works is available. So I would urge you not to approve this, even with the conditions that the city engineer has set, because there's no guarantee that that can be achieved. Thank you.
Thank you.
Anyone else like to speak? I'm going to scan. I don't see anyone raising their hand, either electronically or by video. Ann Marr, who needs to unmute.
Thanks, appreciate it. Hi, my name is Ann Mayer, and that's ANN-MAHER. My address is 50 Prospect Street in Milford, Connecticut. I certainly have the same concerns. We are actually, neighbors, not just of the property, but we consider it a stewardship of being close to the city cemetery. and frankly, speak to it as we have guests that are, I would like to point out a B&B that is currently not accepting guests due to COVID, but yes, we also recognize that that is an ongoing sort of anecdotal point about this MCDD zone that I'd like to make sure that people understand that this zone, in fact, was not predicated by the B&B that resides here. This was pre-MCDD zone. And this was, again, in my letter to the Planning and Zoning Commission, that this was put into a zone where other groups have actually been taken out. My point about section 7.1, and I recognize that there is case law that goes one way and case law that goes another way in terms of what a planning and zoning board can do. But we have, in fact, we are in a historic district here that is nationally recognized. Not only does that nationally recognized district include a greenway that goes into the Wappawag River, we are right at the base of Long Island Sound. So we've talked about that. I will just like to say and reiterate that. Trucks, I see Chairman Cush saying, okay, I'll stop in terms of that, but it's important because we have seen more and more runoff as we've been here over the years, and more development comes through. From a truck perspective, the points that you made were very important. Just this past week, we had several Amazon trucks stop on the street for the development that was across the street that has much more adequate turnaround space. They stop on the street because it's easier to just drop the packages and jump back in their truck. They stop on the street as the fire trucks come up from the corner of New Haven Avenue and Prospect Street and have to go around them. And, you know, we have photos that we can send. I mean, this was not just, you know, this was not just recent. This was not just something that we contrived. It's happening, and it's happening every day. So I would ask you please to consider 7.1 should not just be a throwaway. If it was a throwaway, it wouldn't exist in the regulations. 7.1 does not give you omnipotent power. I recognize that. I'm not suggesting that that's the case. But 7.1 exists because character of a neighborhood, transit oriented or not, is important. Scale of a neighborhood is important. And if what we want to do is turn around and say, the scale of this neighborhood is important for development of apartments only, that will eventually run off into the river, that will eventually run off into Long Island Sound, then that's what we're saying this particular part of MCDD should be. This is not River Street. This is not Broad Street. This is much more akin to those sections of MCDD that have gotten pulled out, like Lafayette Street. So I ask you to please keep that in mind, that there is a lasting impact here that will be not just environmental, but also change the neighborhood of downtown Milford, far beyond what we're dealing with right here, right now. It is building as we speak. Thank you very much for giving me the time, and I appreciate all your time.
Thank you. Thank you for your thoughts and your comments. David, is there anybody else that has indicated they want to speak?
I'm looking. I do not see anyone raising their hand, either electronically or the old-fashioned way. Raise your hand if you want to speak, going once. Raise your hand if you want to speak, going twice. Mr. Chair, there is no one else who would like to speak. Mr. Oliver wants to speak again. I don't know if you want him to.
Ray, if you want 10 or 15 seconds, go ahead, but
Yeah,
let's not do it again.
very briefly, the one thing I didn't touch on, I was glad that the developer addressed the comments about screening and buffering the building to the cemetery. I'm a little dubious that those little junipers, excuse me, will have much effect. And I would hope that we would have some taller deciduous trees in addition to those arborvitae type plants. Thank you.
Thank you. Seeing no other interested parties in the public, I would like to ask the board members to each, as they see fit, weigh in on what their thoughts are or ask any questions of either David or of the applicant, either Manny or Thomas. So yeah, I would encourage everybody to, inquire as they see
Chairman,
fit,
Mr.
or
Chairman, I think the developers have done everything humanely possible they could do to make this acceptable. And I think that this should go forward.
thank you, Joe.
Mr. Chair,
Yep.
before you go through the board members, can I just respond to the comments from Mr. Oliver and Ms. Mayor?
Well, we're already into this. You'll have your last.
Okay,
Yeah, you'll have your chance to close it.
okay, thank you.
Anybody else from the board like to weigh in on either their thoughts, feelings, or questions to be asked?
Yep.
Mr. Quick.
Yes. Peggy, is that you?
Yes, it is. Obviously, this is a really difficult situation, I think, for everybody. It's just my opinion. I wish the developers had found a different spot to put their project. There are a lot of other places in Milford, I think, that this project would fit better. So that's just my feeling.
Fine.
Mr. Chairman, if I could just
yes, John.
comment for a minute.
Please.
I want to agree, number one, with Peggy, what she just said. Would have been nice, but we are here, and that's reality. Drainage and the flora, all that those are also, I guess, in play here as far as a decision. But to me, 7-1, as Ann Mayor said, it is there for a reason. I just think the scale of the project is a little, it's large. It's basically the entire lot is being taken up by the size of the apartment complex. It seems to me it's just the scale is too large. If we could be reduced a little bit, I would be, I think that would be a good compromise. But the way it is now, I'm just having a real trouble reconciling the neighborhood with the project. So those are just my thoughts.
Thank you, John. I appreciate you sharing them. Anybody else?
Yeah, Jim Cater here.
Yeah.
I agree with Peg and John. They both bring some good points up. And, and I think they've done a lot to kind of compromise and try to make it better. But I can't help but feel the same thing. It's just a little bit too big for there. I mean, I can't see them wanting to scale it back, but if they did, they sure would make me feel a lot better. I mean, but yeah, I definitely have some concerns about that, but that's about all I can really say, I guess. Other than one other thing though, is I do note he showed a quote, it was reluctant, the drain, as far as their drainage, it was reluctantly approved. That's part of my concern is it seems to be people are kind of doing what their hands are tied. They're reluctantly approving. We're going to reluctantly probably approve this. I think people just, their hands are a little bit tied. That's what I feel like. We're all kind of stuck in a situation. I know they think they're doing a great project. They got to make money, but we also have a neighborhood we're worried about, and this project's encroaching on that whole neighborhood. So that's about it.
Well, thank you. I appreciate your thoughts. Anybody else?
Mr. Quish, Mr. Sadi.
Yep. Go
So I had a couple of problems getting off and on, but I'm on. I've been watching for about probably 20 minutes now or so. Just the issue of 7-1. I think that public safety and the parking is an issue, and obviously the neighborhood and the material that the community of the neighborhood. But I do think that if somebody's going to be making a motion, they ought to consider the following additional conditions of approval. And the first one goes back to the stipulated judgment that was entered into last year. And that is that the Baldwin House materials be relocated at an appropriate, at or near the approximate point. But the stipulation is that no certificate of occupancy to any building or residence on said property until all of the satisfactory completed work pursuant to that particular paragraph. That is one thing that's requested by the Historic Commission. I know it's in the letters. And the other thing is that the concern we've always had about the water, and I suggest that one other consideration for, so I might be making the motion is that they would put language in any future discharge of water and runoff shall be the sole responsibility of the owner of said property.
Thank you.
I have
Mr.
nothing
Sadi.
further to say. Thank you.
Is there any other further questions or comments? I would like to say something. And David, if you would indulge me and screen share 7.1 from our regulations.
Yep, give me a second here.
Yeah. So, I do appreciate the, I see a lot of people on that maybe have spoken in the past, and this is obviously right in downtown. It is something that everybody, wherever you live in the city, holds downtown area dear, whether they own the property or not. So it's part of our heritage, part of what brings people here, part of why Milford is as great a city as it is. Not the only reason, but one of the reasons, and it is that historic element that we must be stewards of, and I don't know how well we are or are not doing it. But, if you will indulge me, I'm going to read this. It's 711. Let me just. I'm trying to find it. It's the board shall consider. And you're going so fast I can't.
I'm looking for that the language.
I think it was 7.1.3 where you.
Yeah, I think you're right, Jimmy. Yeah, right there. In approving any site plan, the Planning and Zoning Board shall take into consideration the public health, safety, general welfare, the comfort and convenience of the public in general, and of the immediate neighborhood in particular, and may attach such reasonable conditions and safeguards as a precondition to its approval. Now, I understand that the case law that Attorney Lynch, brought up was something that and I did read the case personally, and I'm not a lawyer, but I can read, and it really talked about you can't, and the particular case he brought up was the board approved something and someone else disagreed with the approval. So it's a little bit inverse, and the inverse doesn't always react the same way to a particular set of language. But at any rate, we're not going to bring this to a judge right now. But I think that what we're seeing is that we are not only entitled, but we're obligated to. It says that we shall take into consideration the public health, safety, and general welfare, the comfort and convenience of the public in general, and the immediate neighborhood in particular. Now, this is language that is significant, and it's not may, it's shall. So it's up to the board, and we are told that we have to do this. We have to take this into consideration. It doesn't necessarily give us the right to reject or deny the application, but it does give us some discretion in conditions, as long as they're reasonable. And I think that in general, this board's always been reasonable. I just wanted to get that into the record that whatever happens hence is grounded in an understanding that the whether it's a city attorney or the attorney for the applicant, whatever they say about what they think case law says or doesn't say, that's an opinion. And the thing about law and courtrooms is that there's always different opinions and different lawyers quoting the law. So, and we're not in that case, but I just want us to know that 713 tells us that we shall consider this. Not that we may consider it, but we must. So anyway, at this point, seeing nothing else from the board, if any, I'll hear it. And nothing else from the public. If there's any, I'll hear it. If not, the applicant gets to close.
If I could
Mr.
just say one more
Quish.
thing, Mr. Chairman?
Yep, go ahead, John.
Okay, I just wanted to point out 7.1.3.1, since we're citing the case, the regulations rather, it says the proposed use shall be of such location, size, and character that in general, it will be in harmony with the appropriate and orderly development of the district in which it is proposed to be situated and will not be detrimental to the orderly development of adjacent properties in accordance with the zoning classification of such properties. So this
Well,
is
no,
when
thank you.
I say, I think the scale is too large. Basically, that's.
All right, well, thank you. I think that's, this is the language that's been in our zoning regulations for a long time. It's there for a reason, as one of the public members said. Thank you, John.
Mr. Quish, Mr. Sadi, briefly also.
Yep.
Because Mr. Lynch is going to get a chance to rebut the individuals, and you may determine tonight to close the public hearing. I'd ask that either Mr. Lynch provide an opinion or a waiver if we go to that point of allowing me to vote on this matter. If he doesn't want me to vote in this matter, I think that we should keep the public hearing open for me to review, because I recognize clearly, I think that Attorney Lynch would agree. I didn't see every single minute of this because of problems with my computer, but I've seen a major portion of it. So we're not at that point yet, but I think that before you get to the issue of determining closing of the hearing, if it's closed, I'd just like to get an opinion from Attorney Lynch whether he's going to allow me to vote or not, or make motions or not. Thank you.
Thank you. Hear more from the board. Seeing none. Attorney Lynch, do you have the last word?
Thank you. My first comment I'll direct to Bob Sadi. Bob, you may want to unmute. Did you hear the portion of my statement where I spoke of the case Smith versus the Milford Planning and Zoning Board?
I did not hear it, but I read the case and I'm aware of it.
Okay, I just wanted to make sure of that. Okay, all right.
I did.
So I have a couple of comments I want to close with. First of all, in terms of Ray Oliver, and Ray and I are good friends and I respect him greatly, but Bob Heise's memo to the board speaks for itself. And I think that the drainage issue has been really gone through by all three of the engineers. And again, our engineer came in with a plan that he felt was adequate to service this property. It was approved by your city engineer. So in my mind, end of story. You then had Bob Heise, who came in and had comments. We set up a meeting. Bob was part of that meeting, and his letter submitted to the board said that he's accepting the plan as submitted. There is going to be a further determination of the water table through test borings, and if that results in a change in the plan, that can be addressed at that time. But again, Bob Heise's report speaks for itself. So with Ray trying to supplement those compliments, I think that's something that the board should just read Bob's report and take it for what it is. And then secondly, in terms of, again, I spent time speaking to you about section 7.1 of the zoning regulations. I spent time talking about a case that specifically addressed those regulations. And, you know, you can have legal opinions one way from one attorney representing one party, an attorney representing another party. But what I presented to you tonight was a judicial opinion. So that's not a legal opinion, that's a judicial opinion, that's case law. That's what the law says. And the law says that the language of section 7(1) of our zoning regulations creates general statements of purpose of what a use in an area should be or not be. And if we were proposing a special use that was non-administrative, if it was something that was a use that was able to be looked at legislatively by the board and analyze whether or not the site plan presents a use that's reasonable to the area, those are the standards that section 7(1) talks about. But that's not the case here. We have a permitted use. We have a site plan with a permitted use, and that's a whole different can of worms. A permitted use by definition, not general statements as set forth in section 7(1), but by definition, a permitted use has been deemed to be a use that is comparable and compatible and, quote, in harmony with the area. And in terms of talking about the scale of the building meets all of the standards of the MCDD zone. There was no variances sought here. There were no waivers sought. The building and the lot coverage meets the standards of the zone. So, you know, you can look at a building and say, well, I don't particularly care for it, but if it meets the standards of the zone, the board's discretion in reviewing a site plan is limited, that if it meets the standards, it has to be approved. So again, it's not just my opinion, it's not just John Bertram's opinion, it's the decision of Judge Mancini in this case. And it's one case that, again, is right on point because it's a case that analyzes not Bethel's zoning regulations, not Woodbridge's zoning regulations, not Trumbull's zoning regulations. This is a case that specifically reviews section 7(1) of our zoning regulations. And the court held that there is no discretion granted to the board in reviewing a site plan that has a conforming use, and if the site plan meets all the standards of the zoning regulations. So that's my closing statement to you, and I appreciate the time that you've spent considering this. It's been, you know, a long 3 nights, but you know, I trust that the board will do the right thing. Thank you.
Well, thank you. Again, not to, because there's no more banter, I just do want to say that I read the case, and the case specifically said that you're not entitled to deny an application, and that I understand that, but reasonable accommodation could be requested. And so when you say that it has to be approved, I would disagree with that. I would say that that we do have discretion and ask for indulgence on the developer to accommodate things like scale, things like harmony in the neighborhood, things like public health. However, we as a board would decide that, but we'll disagree on that one again tonight. So at this point, without the applicant has had the last word, we will close the public hearing.
Mr. Cush, before you close the public hearing, before you take
Okay,
that
yeah.
step, you know, I would ask that I have the authority to act if you close the hearing. We go to the adjudicative phase. That's where we make motions and discuss those motions. I read all the written materials, but I do recognize for the record that I had technical difficulties for a portion of this particular proceeding. So I suggest, unless Mr. Lynch on behalf of his client agrees that I can be participating in the adjudicative phase, then we shouldn't close the public hearing. Allow me to review the whole materials that were presented by way of the YouTube and continue that to the next hearing. I think that's appropriate. Otherwise, I spent a lot of time and effort on this, not being able to participate. It's not fair to me and my constituents that I represent.
No, that's fine.
And I agree with that. I agree with that. So I have no objection to keeping it open so Bob can familiarize himself with everything that was presented tonight.
So you're saying that you're in favor of keeping the public hearing open for Bob to review stuff and take this at the next meeting?
Yeah, for that limited purpose, yeah. I'm not going to present anything further, and I would expect that there would be no public comment any further.
No, it would just be board discussion and a motion and discussion of the motion and voting.
Okay. That's fine.
Okay.
I mean, Mr. Quick, sorry to interrupt, but the other option through you to Attorney Lynch was if he agrees that he would let me participate if the board wants to do the adjudicated phase tonight after closing the hearing, that's the other option. If he feels more confident, he wants me to review the materials, I'm willing to let him make the choice either way.
So I'm okay with Mr. Sadi's suggestion to leave it in your hands. If you're okay with stipulating to Bob being able to either make motions or discuss motions, or would you prefer to wait?
Well, I thought that Bob felt more comfortable in familiarizing himself with anything that he missed while he wasn't part of the meeting. Bob, is that correct?
It is correct, but I also recognize that we've had 3 meetings and I'm willing to, I listened to part of it, but I didn't hear every single part. I think the part you felt was important. I know the case and I know your position on it.
Right.
I'm willing to do either way you want, but I know that this is going to kick it out for another 2 weeks.
Well, my main concern was that you were familiar with the Smith versus Milford P&Z case. So you read the case.
I read it. I'm very familiar with it.
All right. Then if you feel that if you feel comfortable in participating in the adjudication, then that's fine. I thought you wanted to have it left open so you could hear whatever you missed.
My point was if the board, after the hearing is closed, takes the position that they want to take a vote on it tonight, I'm ready, willing, and able to do so. But I think you need to waive that ability because we recognize with technical difficulties. I didn't hear every single word of the hearing.
That I don't have a problem with either.
Okay. So thank you.
Okay, so if we're all in agreement from the board, we will close the public hearing. Okay, without objection, the public hearing is closed. I would like to hear from everybody, anyone who wants to speak on their feelings on the case.
Mr. Chairman.
Go ahead, Joe.
Yeah, through you to Dave. Dave, the proposed conditions you have underneath the motion, have those conditions been satisfied?
Yeah, I mean, again, the city engineer had no issue with the proposed drainage system.
Okay.
And he told me that, there's no change from his February 11th letter after meeting with the other engineers. We have confirmation from the fire marshal that the plans were submitted that addressed his issues regarding I believe it was a fire hydrant and some striping. And the latest set of plans, and I think the last set of plans, addressed making sure that the Baldwin House would be restored with wood, but it wouldn't hurt to have, to reiterate the conditions of the Historic Preservation Commission, which is that the bronze plaque would be installed in accordance with the stipulated agreement with them.
So, Mr. Chairman, if I wanted to move the motion, I would only include number 3.
I don't have that motion in front of me, Joe, so I would say that if there are conditions on the motion that is given to us as a template, whatever you feel is important would be your motion. I mean, I think that as we go on, I'm personally going to ask for more robust planting to reduce the visual scale. So I think that any motion may very well float around a little bit and maybe part of the discussion.
Well, I mean, I would move to approve the petition of Patrick Rose Tizol and Company for a site plan and coastal area management review for a proposed mixed-use commercial building on map 54, block 817, parcel 6, of which 67 Prospect Street LLC is the owner, with the condition that a bronze plaque shall be installed in accordance with the stipulated agreement with the Milford Historic Preservation Commission.
Okay, so, and again, you're welcome to make that motion. I'm gonna let everybody have a chance at telling us what they think about the project first, and then we'll have the motion. It could be that no one else has anything else they want to say, so we can move right into motion at that point.
Well, I just
If
made the
anybody else would like to either question David or make a statement before a motion, now's the time to do it.
Let me ask, can I ask a question?
Yeah.
So, say what, if a motion does go through and it gets voted down, what happens? What if enough of us don't agree with it? I'm not sure what.
Yeah, so David, you can answer a procedural question.
Sure. The motions are always proposed and in the affirmative. So, any motion, even if you dislike the motion, is always, you move to approve, you move to approve. If you disagree with that motion, then you are not with the motion, which means you disagree with the motion.
And so what happens if the motion to approve with whatever conditions fails?
You can make another motion. You could call it a day.
And is there a time period where this is automatically approved if we don't act on it?
Well, yeah, I mean, it's a site plan approval, so there's a clock that's ticking if you don't act on this, and if the applicant.
If approval is denied, explain to us all what happens then.
You took an action, you denied it, done.
Right. So we didn't approve it.
Right, but you took an action, you did what you're required to do.
Right.
You're not required to approve every application.
So then what happens?
So it's a denial. So the applicant could appeal your decision. The applicant could resubmit. They could modify their plans. They could do nothing.
Okay. All right. So there's no automatic approval. That's only in a situation of inaction.
Correct.
Okay, understood. I want to make that clear to everybody.
Right.
So without anyone else wanting to make a statement.
Mr. Quish, I have something to say too. Thank you. And this is probably through you to anybody that I said before that that number 3, that condition number 3, when the letters we got from Historic Commission, I suggest that the language would be that no certificate of occupancy of any building or residence would be permitted until that work, which is in number 3, it's called paragraph C, is completed. So in other words, they can't do the house last and put everything up and get certificates of occupancy. They have to do the house first. And then I also ask any proponent to consider the issue of discharge of water. And I had proposed that language that any future discharge of water would be the sole responsibility of the owner of property. Again, I toss that out to people considering making motions. We might try to amend them at some point down the road. But I just think it's important that if 3 is going to be proposed, that there be a requirement as the stipulated judgment that no certificates of occupancy could be done in the 2 buildings. The one that's attached to the Baldwin House, I call it the new portion of it, and then the mixed-use building until the work on the Baldwin House is completed. That's all. Thank you very much, Mr.
No,
Quish.
thank you. That was I think that was a recommendation of the stipulated settlement, or we saw that language somewhere.
It was. It came out of stipulated judgment.
And I would actually like, and again, I'm not going to make the motion myself, but I would like whoever makes the motion, and I will advocate for this at any event, that we ask for more robust plantings that create more of a visual barrier, so that what we have, so we all, I think, believe that the scale is not perfect for the neighborhood, but we also understand that it is a permitted use. So we're in a little bit of between a rock and a hard place as a commission and as a board. But we have got some accommodation with a turnaround for trucks delivery trucks and the like. And I would ask for some accommodation to not have to wait 15 years for the trees to eliminate, like the scale is a visual thing at one point. The people who rent the apartments in the back choose to do so, and it's probably going to be a nice place to live. And it'll probably function, you know, and obviously the stormwater issue should be in the motion to make sure that if there are different groundwater conditions based on new testing, current testing. But I would like to see that from the street. And so that's the public way we look at it, is that we have a reduction of that disparity of the scale right from the get-go, not waiting 5 or 10 years or 15 years for these trees to get big, but to put in, you know, more mature trees, or to have, you know, to try to reduce the impact of the out of scale nature of the development. That's what I would ask in a motion, but I will hear any motion. And
so Mr. Chair,
yeah,
Mr. Chair, just to keep things nice and neat, you have a motion currently on the floor.
we do not.
Yes,
Mr.
Mr. Castagnoli made a motion.
I interrupted his motion.
Yes, you did.
Yeah.
So
so let's go back to Mr. Castagnoli and let him make his motion for the record.
I move to approve with the following modifications. The original house siding shall be rehabilitated with wood. A bronze plaque shall be installed in accordance with the stipulated agreement with the Historic Preservation Commission. Any groundwater runoff will be the responsibility of the owner. Site planting should be above 10 feet, 15 feet, Jim?
15
feet. The petition of Patrick Rose Tiso and Company for a site plan and coastal area management review for a proposed mixed-use commercial building on map 54, block 817, parcel 6, of which 67 Prospect Street LLC is the owner.
Okay, thank you. We have a motion. Do we have a second? I'll second the motion.
Thank you, Jim.
Okay, so we have a motion in a section. Now we can have discussion about the motion. What is it about the motion that the board disagrees with? Because we, you know, is there a position that the board members are taking that they would prefer to deny this and, you know, have it take whatever course?
No.
Or are there other conditions that we'd like to add into an approval that maybe that Joseph and I can agree to amend the motion and amend the second? Peggy?
Well, I just had a question. Am I muted? I'm sorry.
Nope,
Nope.
you're good.
I like Mr. Sadie's idea of having the house done first. Was that in the court findings, the settlement, that it was done first, or that just that it had to be done at some point?
I think, David, can you speak to that? I think the original language was that you couldn't get a CO on the new construction until the renovation was completed and accepted.
To be honest, I don't remember. I'd have to go back and read it. Perhaps Mr. Lynch can tell us. But,
Yes, you're welcome to speak up, Mr. Lynch.
Something wrong because the public hearing's been closed.
Oh, yeah, well.
Okay, all right, so we'll figure it out on our own then.
I want to wink and say, yeah, that's right.
So Mr. Quish.
I'm glad I didn't hear you say that, but.
Mr. Quish, I'm sorry for speaking over Attorney Lynch, but Mr. Sadie here.
Yeah.
The language that I read to you, this is the third time now, comes directly from the stipulated judgment of September 21st of 2020.
Okay.
The first part of that is completely accurate as to the motion made by Attorney Castagnoli. There is a different portion of that said that this paragraph, which is the one that they refer to as C, but the one about the bonds bronze, black, and stone. The language I said, and I'm quoting from the stipulated judgment, must be completed before the certificate of occupancy is granted for any portion of the apartment building or site.
Okay, so you know what I would ask, Joe, is that we amend your motion to approve to just include in its entirety the stipulated agreement.
So moved. I'll agree.
Okay.
Sure.
So you're okay with that? I'm okay with that as a second. Is there any other conditions or any other amendments that any of the board members would like to make to this motion before we vote on it? Meg, can you piece this puzzle together and read the motion again before we vote on it? You're muted.
Okay, this will be a challenge.
Got the discharge is the sole responsibility.
Right, just give me a second. So Mr. Castagnoli moved to approve the boilerplate of the agenda with the proposed conditions of the original house siding shall be rehabilitated with wood. A bronze plaque shall be installed in accordance with stipulated agreement with the Milford Historic Preservation.
Hey, Meg, I think if we just stipulate the entire agreement.
That's what I was about to
I think
say.
we can eliminate that first part, talking about the siding. If we,
All right.
if we include the entire stipulated agreement, that's in there, so we don't need to be redundant. I
So,
don't think.
so the original, how about this? The original house will be restored in accordance with the stipulated agreement in its entirety with the Milford Historic Preservation Commission.
Okay, I mean, I think that's redundant, but it's okay. It's accentuating it. And so we have that, and we have language for.
And then there was the runoff is the responsibility of the owner, and all trees. I assumed it's all trees. I didn't see them characterized as deciduous or whatever, shall be above 15 feet tall.
Yeah, so I don't think that was the intent of my discussion. My basic interest was in the trees that are between Prospect Street and the new construction.
So
which
all
would be
trees
to the left of the existing structure.
Okay, so all trees to the left of Baldwin House, or to the, what would that be, north of Baldwin House?
Yeah.
Shall be above 15 feet.
Tall. I think the wording should be, shall be a minimum of 15 feet tall.
Shall be a minimum of 15 feet tall.
Planted at a minimum, yeah.
Okay. And all the CO discussion and so on got incorporated in its entirety.
I think on the height of the trees, we don't want it to be 15 feet when they're grown, like in 5 years.
No,
we want
15 feet as planted.
As planted, right.
Does that sound okay to you, Mr. Castagnoli? Okay, so that sounds good to Mr. Castagnoli, and my second is in concurrence with that language. So we have a motion and a second. Is there any further discussion on the motion?
Mr. Sadi, I'd like to speak on the motion, if I might, please. Mr. Quist, thank you, Mr. Chair. I suggest that I'm very familiar with the record here. I'm familiar with the case cited by Attorney Lynch. The comments made by the board chair about what we shall consider have been taken into account. I think that we have to recognize that the public hearings we've had over the last couple of times brought out two things I suggest that are important. First and foremost is the way that the community looks. So is the project too big, or is it a proper size for the community? And that comes out of 7.1.3.8. that the character and appearance of proposed buildings and structures are similar to the community. It's a paraphrasing. They also complained about, and I shouldn't say, they also commented about the issue of the parking and the issue, again, we heard this evening with Mrs. Marr regarding the trucks, and is there a proper turnaround at the project lower behind, below that, closer to the railroad tracks, does have a proper turnaround. So those are things that are concerns for the community. And finally, the concern for the community was the issue of the runoff of water, which is a general, I think I suggest goes into the general 7.1.3.1 and just 7.1.3. So those are concerns that the members of the community have. I've not made up my final mind on this, but I do share their concerns. I also recognize the position, the appropriate position Attorney Lynch is taking, that if it is zoning compliant, we have to approve it. Now, I do suggest that the question is, even though we have a report from our planning official, is it, and we have to make that determination, is it zoning compliant pursuant to 7.1 and the different subsections? Again, I have not made my mind up on it yet, but I am considering all those particular factors to either grant or deny this that is voting for the motion or against the motion. Thank you very much, Mr. Chair.
Well, thank you. Is there any other questions or comments from the board?
Hey, it's Nancy. I tend to agree with what Bob just said too. I mean, this is not an easy decision, and I think there's a lot of factors that go into it. So that's where I sit right now.
Well, so we do have an option. The public hearing is closed, but we do not have to vote on it tonight. We can consider the record. We can consider our own thoughts and vote on it at the next meeting. Is that something that the board feels
What do we do
comfortable
with the motion that's already on the floor?
It would still be on the floor. We
Okay.
could still discuss the motion.
Okay.
And, gives us time to reflect. I mean, we have two people that feel like they're not really fully committed to the vote. I think we should give them time to consider it.
Can I say something too, Jim?
Yes, please speak up anytime.
Yeah, I hear Nancy and Bob, they make some real valid points. I mean, there's a part of me that really thinks it's going to benefit the downtown. I think people living in the area nearby are going to support the restaurants and all the clubs. That stuff's really important to me. But I also I'm having trouble getting past the impact on the neighborhood there. It's a historic area. And, kind of we're supposed to be also representing the city, the people, the neighborhood, what it is they want to see the city become. And if we're not kind of listening to them, then who are we listening to? Just to business people. So I'm kind of torn. Again, I said, I think it's great for this downtown, which I want to see downtown come back, but I'm really torn too.
Yeah.
I know which way I'm leaning, but it is a tough one. It really is.
And one thing that I think can inform your own thoughts a little bit is that it's the third public hearing, and we only had one person that wanted to speak, or two people that wanted to speak tonight. So, when you talk about the community, I didn't see him tonight. I didn't see him. Very many of them, they're here, but they chose not to speak. Anyway, we know what they were going to say. I'm just saying in general, it's not, you have a chance to vote your heart. And I think that because it is a complicated issue, that is wholly appropriate to put off the meeting, the vote till next meeting. We will have a motion and a second on the floor, and the board's discussion will be open, and will be open to question staff. So without objection, we will push this off until the next meeting. Okay, without objection. Next is old business. We have none. Liaison reports. I see none. Subcommittee, we have subcommittee meeting minutes on the website. We had a plan of conservation and development meeting last week, and we discussed the MCDD, Milford Center Design District. These are available for the public to watch. Next week, we will have both the Regulation Subcommittee and the Plan of Conservation and Development. Plan of Conservation and Development will be discussing the, I think it's called the
Mall.
retail, what's the,
Well, the shopping center district.
your shopping center district. So that'll be, it's not a public hearing next Wednesday, but it will be open for the public to listen. So, you know, I would encourage people in the public to come in and watch, and you can always send questions to David. And we will have public meetings coming up on both committees in the future. We have approval of the minutes. So we make a motion. Joe's made a motion, I second, so moved. Without objection, staff report.
None this evening.
Okay.
Before you, Mr. Chair, before you adjourn, please, Mr. Sadie, again, sorry to interrupt. I don't mean to take your job away, but would it make sense to have the motion that was so eloquently spoken by you and Attorney Castagnoli be typed up by the secretary, submitted to all members? So within 2 weeks, we know that we're on the same page. Does that make sense to the chair?
It does. Very good suggestion.
Thank you very much.
I think Meg probably would have done that for us anyway, but now that you asked, she's gonna have to. Okay.
Now
so-
I really can't resist.
So we have motion to adjourn.
Motion to adjourn.
Okay, thank you, everybody, for your time, patience,
Thanks.
and attention.
Have a good night, everyone.
Bye.
So
And